this is working. No, this is new. I press main jail.
It's like a little more.
It's okay, I'm used to it.
Oh,
Nobody.
Yeah?
No.
Basil, can you hear us?
Can you hear the court?
Yes, Judge.
Oh,
Okay, calling Marcus Mathis.
Step up.
there he is. Brian Greenwald on behalf of Marcus Mathis. Judge, he is here on a violation of probation warrant signed March 11th by Judge Backman. That original warrant was signed in error, and we have an agreed order that was signed September 29th. It was entered into the clerk's system September 29th. You can see it on your system, Judge. It's an agreed order dismissing the warrant dated March 11, 2016. That's the only reason Mr. Mathis was transported back from the Florida State Prison. He was sent to the Florida State Prison. He completed his sentence. Once they completed his sentence, this popped up from Broward County. Once I realized that this was entered again in error, we had an agreed order to have it dismissed. Unfortunately, the timing just didn't make it to the system before he was transported back down here to Broward. But again, the state can verify this is the only thing that's holding Mr. Mathis in the Broward County Jail.
See a copy of the order?
Absolutely.
And counsel with the state, are you in agreement?
Can I see a copy of the order as well, Your Honor?
It was an emergency basis, and since Judge Backman was out this week, his judicial assistant, Pam, had us take it to Judge Colbert to sign it, which he signed it on September 29th.
Based on this order, Your Honor, the state has no objection.
Okay, so the court is going to release Mr. Mathis.
Thank you very much, Your Honor.
You're welcome.
And good luck, Marcus. I'm sorry about the confusion.
Have a good day, sir.
Thank you, Your Honor. Have a good day.
Okay, at this time, calling Travis Christopher Taylor.
Medical reset. The first case, right, Your Honor? Travis Taylor?
Yes.
He's a medical reset.
Okay.
Gentlemen.
Is that just signed? Oh, no, this one. Put your date on the balance. This is a medical recess. Tony Lamarck Walden.
Present at the main jail.
Mr. Walden, you have been charged with touching or striking, battery, domestic violence. You have an attorney there present with you. The court is finding that there's probable cause. Anything from the state?
Your Honor, at this time, the state would be asking for make sure that there's no victim contact with the victim in this case.
There will be no contact with the victim.
Judge, may I get into his ties? Ties to the community?
I'm sorry?
May I get into his ties to the community?
Go ahead.
Judge, he's been living here all his life. He's currently gainfully employed. He works in lawn service. He does have $50 in his property at the jail right now. He was born and raised here, graduated from Deerfield Beach High. He currently has a place to stay separate and apart from the victim in the case. He'll be relying on his family to post bond. I would ask the court to set a $1,000 bond.
And Your Honor, just in considering the bond, I'd also like the court to just consider the probable cause affidavit in and of itself, where the independent witness does state that the alleged victim in this case exited her vehicle with a metal object and began to argue with him. So it seems like she was the first aggressor in this case, Your Honor, before he did anything to her, Your Honor. She was the one who approached
Your
him.
Honor, I would have an objection that defense should be arguing the legal basis if they would like the bond to be increased or decreased, not factual basis, Your Honor.
What's the
What's the
state's
objection?
objection to setting the bond at $1,000?
I would just ask, based on the criminal history and the facts of the case, that it be set at, if you could, $2,500, Your Honor.
What criminal history?
In 2015, there's a possession of cannabis withhold, 2012 grand theft withhold, 2011 possession of cannabis withhold, 2011 strong arm robbery with a mask that was dropped. There is some TC traffic criminal in 2008. In 2008, there's also possession.
These charges or convictions?
They are convictions, Your Honor. Well, withholds. Some of them are withholds.
Court is going
And Your Honor, my apology, but just in considering setting the bond, it seems like this can be a factual, and in terms of the facts of the case, he could have a possible self-defense, defense in this case. So I would ask the court to consider that when setting his bond amount, as he wasn't the first aggressor.
The court is going to set the bond at $1,000. Conditions of the release is no contact with the victim. Good luck to you, sir. Karen Brighton.
North Broward Jail, Your Honor.
North Broward, she's a medical reset.
Okay, thank you. Tomorrow. Jennifer Gal Johnson.
North Broward.
North Broward? Yes, ma'am.
Ms. Johnson, you've been charged with with a municipal ordinance violation, open container. Do you
Yes,
understand
ma'am.
you have the right to have an attorney, and anything you say, you have a right to remain silent. Anything you say can be used against you.
Yes, ma'am.
And court is going to find probable cause. And the bond is set at $25.
Your Honor, will the court appoint counsel in the case? There's nobody here from the city, or nobody. There's not a city public defender there either. And depending on if it's from Fort Lauderdale, there's an attorney, Jara McLawrence, that represents clients from defendants from Fort Lauderdale, or a Steve Shate that's based out of Hollywood, Dania Beach. I just don't want her to get lost in the system.
It's a Fort Lauderdale case, so you said that there's an attorney that can be appointed for her?
Yes, Judge. Jara McLawrence would be that attorney.
Okay. I'll go ahead and appoint that person to be her attorney.
Thank you, Your Honor.
Okay. Done? Sorry, my arm.
Go ahead and get on next.
Jessica Marie Wright Butler.
North
Yes.
Broward?
Good morning, ma'am. You have been charged with petty theft, first degree. Court
Yes,
has
ma'am.
reviewed the probable cause affidavit and it's finding probable cause. The bond amount is yes?
With Ms. Wright Butler, we're asking if the court will consider releasing her on her own recognizance. She has no felony convictions, Your Honor. She currently lives with her mom in Coral Springs. She's to be starting a job at Harbor Freight on Monday morning, Your Honor. She's lived in South Florida for the last 13 years, and a majority of her family does live in South Florida. She's a registered voter. She does have a driver's license here. So she does have strong ties to the community. In speaking with her, it doesn't sound like she's ever missed court before. So we are asking if the court will consider releasing her on her own recognizance.
Any objections from the state?
My only objection, Your Honor, would be that she does have a pending case in front of Judge Miller. It's a traffic criminal case. But I do agree, I do not see any priors for this
The
defendant.
court is going to release her on her own recognizance. Good luck to you, ma'am.
Thank you.
You can get on next. Which attorney?
Adele Michelle Hayton,
North Broward? That's you?
North Broward. Okay.
Michelle is my first name.
Michelle Hayden?
Yeah.
I'm sorry?
Yeah, Michelle is my first name.
Okay. You have been charged with DUI, alcohol, or drug first offense. That's your first charge. Your second charge is DUI with a, what does that stand for? With a DAM to property or
Okay, when it
with
comes
damage
up.
to property or person of another. And the court has reviewed the probable cause affidavit and it's finding probable cause. Anything from the public defender?
Yes, Your Honor. In speaking with Ms. Haddam, she indicated she is unable to afford the current bond, Your Honor. Her family may be able to afford something. She lives alone, Your Honor. She does work at Express Tray. She's lived in South Florida all of her life. She is a U.S. citizen. She's registered to vote in Broward County. She has her driver's license here. She's never missed court before, Your Honor. She indicates that because she lives alone, her rent is due and she needs to get out so that she can pay that, and so that would restrict her finances. We are asking that the court would consider releasing her on own recognizance or, in the alternative, lowering her bond amounts.
State.
Yes, Your Honor, I would object. These bonds are the standard bonds set for these kind of charges, and for this case, it's a DUI. It is a threat to the community, so I would ask that the bonds stay in place as the bonds that are listed. In addition, she does have a prior in 2010 of leaving the scene of an accident, Your Honor.
Would she qualify for pretrial intervention?
Judge, I've been advised her father posted the bond by pretrial release.
So any objection? Okay, for father's posting the bond, then the court, having found probable cause, is going to leave the bond as set for charge 1 at $500 and charge 2 for $1,000. Good luck to you, ma'am.
Thanks.
Pilar Poro Rivera.
Judge, she's present at the meeting. I'm gonna have her. She has my prior record. Yeah.
Ms. Rivera, you've been charged with DUI, alcohol, or drugs, first offense, in crash, leave the scene of an accident without giving information, specify damage. You have the right to have an attorney. You have the right to remain silent. The court has reviewed the probable cause affidavit and it's finding probable cause.
Your Honor, I would just have argument as to the leaving the scene of a crash involving damage. It does state that she did leave the scene and walk towards her residence, but that she did return. So in that, it's not clear what it was, but Your Honor, she did return to the scene of the accident. There was no, it was a temporary, I guess, a temporary absence. She did return. She did give all her information. She did cooperate with the police officers. So I don't believe there was any intent to leave and not return and not be forthcoming in this incident.
State.
Your Honor, those are all matters that could be discussed in trial or a potential motion, but in this case, she did have the intent to leave the scene as she did leave the scene. We don't know the reason why she came back, which could have been because an officer called her and told her that she had to come back to the scene, Your Honor. She does meet the elements for leaving the scene of an accident, and therefore, the state believes that you should find probable cause.
And Your Honor, just in the four corners of the document, there's nothing here that states that anyone called her back to the scene. It just says, Officer Gonzalez advised me he had been on scene approximately 10 to 15 minutes before she returned to the crash location. So it was a temporary absence. The investigation was still ongoing when she returned. As stated, she was cooperative with the police officers. She never attempted to run or anything. It seems like she lived close by and went to her home and returned to the accident. And she walked on foot and returned on foot. It's nothing here stating that anyone forced her to come back.
Well, I mean, the affidavit does say that she returned, so having returned to the crash location implies that she left the scene.
I agree, Your Honor, but my argument is because it was a temporary, it was temporary and nothing, I don't believe leaving for temporary.
I agree with the state. I think that that might be more appropriate for a motion to dismiss that charge. At this time, there's sufficient in the probable cause affidavit for the court to find probable cause. court is finding probable cause. The bond amount.
Your Honor,
Yes?
may I just be heard briefly as to the bond amount? She does have significant ties to the community. She, unfortunately, her cell phone, she wasn't arrested with her cell phone. It's not in her property. So she has no way to accessing her contacts or calling anybody. There are some medical issues too. I don't believe that she's ever been in trouble before, but she has no way, being in custody at the main jail, to access her money or her property in order to bond out. I could tell you that she's a resident of South Florida she's a resident of South Florida for 30 years. She currently resides in Sunrise, Florida. She resides in a condo for senior citizens. She's been gainful. She was employed. She retired from Motorola. She was employed for 22 years over there. She does get a Social Security check, and she does get a pension. The issue is this. It's not the issue that she can't monetarily post a bond. She has no one to contact. I spoke with pretrial release, and pretrial release won't be able to get somebody to go to her apartment until Monday, meaning that she'll be in custody 2 more days at the Broward County Jail. And based on the medical information she provided me, I'm worried about her health. I would ask, in light of that, for the court to release her on her own recognizance. I would also ask the court to allow the public defender's office to take photographs of her injuries. But if she has no prior record, there's nothing indicating that she wouldn't return to court. She's telling me that she will come to court and she will be present.
Any objection to allowing the public defender to take photographs of her injuries?
No, Your Honor.
Okay, so granted. What's the state's position on reducing removing the bond to her own recognizance based on the fact that she has no way of contacting or accessing her monies to bond out?
Your Honor,
And she has no prior offense, correct?
yes, that's true, Your Honor. I did not see any priors, but I would ask that the bond still be set at the standard $500 for this charge, based once again on the basis of the charges. It is a threat to the community, and like counsel said, she will be able to have contact with people on Monday, so it's just 2 days, Your Honor.
Judge, I would object to the fact the state's saying that she's a danger to the community.
Okay.
She has no history.
Counsel, the court is going to release the defendant.
Thank you,
on
Judge.
recognizance. Can she also be participating in the pretrial intervention program? Again,
Standard trial, alcohol evaluation within 10 days, random drug testing, and reporting pre-trial on Monday.
okay, the court is going to order that. Chantel McPhee.
North Broward, Your Honor. She's out on medical loan. She's at the hospital.
Okay. We'll reset for tomorrow. Kimberly Lavada McFadden.
Judge, she's been released.
Tasha LaShawn Thompson.
She's present. She's making her way up here, Judge. Judge, her co-defendant was here yesterday. I believe Judge Davis set a $2,500 bond on count 1. Minnie Thompson was the co-defendant in the case. I would ask the court to keep the bond the same.
Any objection from the state?
Yes, Your Honor. In this case, I would be asking for the $3,500 bond. Based on her criminal history, she does have a prior battery in 2012, as well as a few juvenile priors that are violent priors, Your Honor.
She just recently had a child. This is a not in custody warrant. I believe the incident occurred in May. I was present here at the magistrate hearing. I know Minnie Thompson, who's also stated in the probable cause affidavit. I believe her bond, Judge Davis set her bond at $2,500. I'm not asking for an increase. I think they both should be treated the same way. So to ask the same bond, bond that was set.
Is Miss Thompson there?
Yes, she's here. She's next to me.
Ma'am, you've been charged with aggravated battery with a deadly weapon, domestic violence, and criminal mischief and the court is going to find probable cause. Based on Judge Davis finding probable cause as to charge one and setting the bond at 2,500, the court is going to do the same as to the first charge. As to the second, the bond is $100, and this is a domestic violence case.
Yes, Your Honor.
No contact with the victim.
No, this is not a domestic violence.
No?
I don't think it is. No.
Yes, yes, it is, Your Honor.
It says aggravated battery with a deadly weapon, domestic violence.
No, it's not. It's not domestic in nature. I don't think they live together. The person who's accusing her and Miss Thompson of the offense, they don't live together or are related.
Right, but is it? Okay. In any event, no contact with the victim.
Okay.
Gina Pia Alfieri.
Medical reset, Your Honor.
Medical reset?
Yes, North Broward medical reset.
Okay. For tomorrow. Dawn Renee McCutcheon.
Yes.
Ma'am, you have been charged with... Ma'am, you've been charged with capious felony, count 1, and retail theft, count 2. Court has reviewed the probable cause affidavit and is finding probable cause. Anything from the public defender?
Judge, I would just ask the court to keep the bond the same. She's being held no bond on count 1, and she has a court date.
When is my court
The
date?
court will
The
maintain
7th.
the bond as is, no bond on count 1, and as to count 2, $1,000 bond. That is on the 7th.
And your court is on October 7th, next week.
Sherlyn Veronica Salcido.
Medical reset, Your Honor.
Medical reset.
Yes.
Natasha Tempest Stewart.
Good morning.
For Ryan, Your Honor.
All right.
Yes.
Ma'am, you've been charged with battery on a public transit employee.
And Your Honor, it looks like there was a change of charge. I did look up in the clerk's system. The previous charge, there was a $1,000 bond. So I'm asking if the court would maintain the same $1,000 bond as there was a lateral change from a third-degree felony to another third-degree felony.
State.
No objection, Your Honor.
If the court having found probable cause is going to set the bond. What's the bond amount?
1,000.
1,000.
And Judge, the magistrate judge,
Can I speak? I don't have any money. I live with my mother. She's on disability, and I've been helping her around the house. I just lost my job.
Stop.
Yes.
Let me advise you that you have the right to remain silent. Anything you said may be used against you.
Okay.
And I'm gonna sign the pre-trial.
magistrate judge, based on 3 trials.
And Your Honor, we ask for no victim contact in this case as well.
No victim contact.
Well, the magistrate judge, based on
Okay. And Your Honor, would you consider, because she was ROR'd on count 1, would you consider ROR'ing her to pretrial release on count 2, since she's already been approved for pretrial?
There's a count 2.
The count 2 is the one that we're here for, that the $1,000 bond was set on.
So instead of having the bond at 1,000, just
ROR to pretrial?
states.
I would ask that the bond remained at the 1,000 that it was set at the original first appearance, Your Honor.
What's your reason for?
She's been in custody all of this time, Your Honor. Well, I believe for the last 12 days. What is it? What day was she arrested?
September 20th, Judge?
She's been in custody, Your Honor, and it's clear no one can bond her out on that amount. So if the court will consider RORing her to pretrial, pretrial can monitor her.
Do you have any priors?
Yes, Your Honor. In 2011, she has uttering a forged instrument. It was a withhold. 2011, theft. It was an adjudication. 2010, possession of cannabis adjudication. 2010, resisting without violence adjudication. 2010, trespass adjudication. 2009, resisting without violence adjudication. In 2009, there's a traffic prior, no valid driver's license adjudication, same in 2008. And in 2006, there's a battery adjudication.
Um,
One moment, Judge, I just found out that you said count one.
Count one, I'm sure that the system that the bond, there was a change of charge that did the petty theft, and, the bond is $25 in count one.
The same, so it changed from petty theft to petty theft?
It was, petty theft plus to be property, 100 to 300.
So,
They're changing those two.
so and she was never magistrated on count one then, since it's been changed to charge.
Since the charge has changed, it looks like they changed both of her charges.
this is the first charge or the second charge?
The second charge has been, the first charge has been changed as well. We're here today on the second charge, but she's given us information that the first charge has also been changed. That's just not here on the docket to be addressed, but it's also the same, misdemeanor, so misdemeanor. It looks like it went from a petty theft first degree to a petty theft second offense. Am I correct? Okay, yeah. The degree and the petty theft changed. They're both still misdemeanors, so the bond amount, because there's a change of charge, automatically goes from the ROR to a $25 bond.
So the bond is $25?
On the, on
We
count
count
one.
one, which is not, she's not, coming to court on this today, only count two.
So count two is the battery on the public transit employee, and that's a misdemeanor, and the bond is 1,000?
Yeah, that's a felony, but the bond.
It's a felony?
Yes,
Okay.
ma'am.
And are you still arguing that the court reduced the bond or not?
And for, both counts, that should be released ROR to
Well, she's been there now 11 days, and it appears that doesn't have the ability to post a bond. So I'm gonna go ahead and release her on ROR.
Both counts.
Well, I only have one count
We
before
only
that.
have two right now.
So technically, she's still in custody of
Yeah,
count one.
count one.
Yeah. Are we ready to move on?
Yes, ma'am. Sorry about that.
No contact with the victim?
Yes, Your Honor.
No contact with the victim.
Okay.
Monique Nicole Miranda?
Your Honor, I spoke with the deputy and with her, asking because she's a juvenile, address her at the end of the docket.
Okay.
She'll be addressed at the end of the docket.
Thank you.
Kristen Pashi Castro.
Defendant bonded.
Bonded, Judge.
Okay. Eric T. Hunter.
Present at the main judge, making his way up.
Mr. Hunter, you have been charged with violation of probation, misdemeanor. The court entered an order, and it says no bond. Court having reviewed the warrant, finds probable cause.
Got court on October 6th. Yep. That's next one.
Have a good day, sir.
All right.
Garvin Anthony Foster.
Judge, he's present at the main. If the court finds probable cause, he would like to resolve this case at magistrates, if possible, to a withhold adjudication and court costs. If the court is so inclined.
This is city of Fort Lauderdale or city of Lauderdale?
No. This is not a municipal ordinance. I believe this is a state charge.
This is a state. What's the state's position?
Your Honor, in this case, he does have two prior trespasses. Both of them are in 2014. One was an adjudication, one was a withhold. And then he also has a resisting without violence in 2014 withhold. So based on that, the state would be asking for an adjudication, no return, and court cost, Your Honor.
Okay. The court having reviewed the probable cause affidavit finds probable cause. What's the public defender recommending?
Judge, I would ask for a withhold adjudication, no conviction, and no return to the property. I think the only thing we differ on is as to a conviction or no conviction. But I'll defer to the court on that matter. But he would like to resolve.
The court is willing to resolve this matter today. The court is going to withhold adjudication, time served, and not return to the property. Anything else?
No, Judge. And for the Mr. Foster is pleading no contest to these charges.
Okay.
Okay, you're done. You resolve it. Good luck to you.
I'm waiving court costs. Do I have to follow through now? Antonio Weston.
Judge, he's present at the main jail. This is a municipal ordinance case. I know when I see 40A, I know that Mr. Stephen Shate would be handling these cases, but the court can also resolve it on its own if he wants to waive the right to an attorney. But I think it seems that he wants to resolve the case.
Mr. Weston, you have been charged with 4 counts. Here it says KP is miscellaneous on the charge. Okay. The first charge is no lodge in city property, owned property. Second charge is carry open, uncover beverage. Third charge, trespass private property. And the fourth charge, carry open, uncover beverage. The bond amount for each account is $100. I understand that you want to resolve this today. Is that correct, sir?
Yes, ma'am.
Court is going to find probable cause. Do we have any information whether there's any priors on this matter?
I can look that up, Your Honor.
What is the public defender recommending?
I wish I could represent him on the case, because I'm precluded from representing cases where defendants are charged with municipal ordinances. But as a friend of the court, I would ask for time served on each count.
There is a 2016 municipal ordinance trespass withhold. In 2016, open container adjudication. 2015, urinating on a public building withhold. 2015, battery adjudication. 2015, trespass withhold. 2015, loitering adjudication. 2014, carrying an open container withhold. And then it goes all the way down to 2004 is the next prior, Your Honor.
Okay, sir, you want to resolve this matter today? Is that
Yes,
correct?
ma'am. Yes, ma'am.
The court is going to withhold adjudication and time served. Good luck to you, sir.
Thank you. Time served? Yep, Your Honor. Thank you. Good luck.
And court cost. Samuel Bean Aim.
He's present at the main, Judge. Come on up, sir. Judge, I briefly did look at the probable cause affidavit. If I'm not mistaken, he's allegedly, I'm not arguing probable cause, but I think the allegations are he took some food. He would like to resolve it today if the court is so inclined.
Okay, well, he's been charged with petty theft, second degree, second offense. What's the state's position?
Your Honor, based on priors, the state would be asking for at least an adjudication. Ideally, probation would be on it. It would be adjudication, 6 months probation, no return, and court cost.
Judge, we're talking about food here. I mean,
I understand, Your Honor, but taking into consideration the priors, there are,
What are the priors?
in 2015, there's a petty theft adjudication, 2014 felony petty theft adjudication, 2014 resisting merchandise recovery adjudication, 2014 battery adjudication, 2014 reckless adjudication, 2013 driving while license suspended adjudication, 2012 petty theft adjudication, 2012 petty theft withhold, and then a driving prior in 2007 driving while license suspended adjudication.
Thank you. The court is going to find probable cause. Sir, I understand you want to resolve this today. Is that correct?
Yes, ma'am.
You got to speak up.
Yes, ma'am.
And
Yes, Your Honor.
how do you plead?
No contest.
Okay. At this time, the court is going to withhold adjudication. The court is going to release you on time served. And just want to caution you that you've had several charges before. Next time, the court might not be as benevolent. So good luck to you.
Your Honor, can you order a no return?
Thank you.
And a no return to the property.
Thank you, Your Honor.
Thank the judge.
I'm going to wait
Thank
for
you,
the
Your Honor.
cost. Have a good day.
Thank you, Your Honor.
You're welcome.
I'm done.
Down the middle, down the middle.
Ricardo Dexter Rodrigo.
He's present at the main judge. This is also a municipal ordinance case, but he's telling me he wants to resolve it without an attorney.
I have here, there's also a misdemeanor capias.
That's what I'm here for. I think parked in a fire lane.
I want to resolve.
I didn't know that was a charge. A criminal charge. I know it's a ticket. I didn't know it was a criminal charge.
This is a municipal. This is a municipal ordinance.
Yes, Your Honor.
It's an MO. What's in the file?
The court has reviewed the probable cause affidavit, and it's gonna find probable cause. What's the public defender's recommendation?
Judge, as a friend in the court, I would ask the court to withhold adjudication. He wants to resolve it.
What are his priors?
In 2016, there's parked in a fire lane withhold, 2016 grand theft of a motor vehicle adjudication, 2016 resisting an officer with violence adjudication, 2016 2016 grand theft of a motor vehicle adjudication and probation, felony petty theft in 2016 adjudication, 2016 resisting without violence adjudication, 2013 petty theft adjudication, 2011 grand theft of a motor vehicle adjudication, 2011 operating without a valid license adjudication, 2010 battery on a specified employee adjudication.
Well, the probable cause affidavit states that he is on probation until 2020.
Okay, Judge, and I just withdraw that and ask the court to appoint counsel. I don't want him to be in violation of his probation.
It's an old charge.
I don't know.
Everything. I want to see how do I get a warrant for this.
Appoint counsel for through the public defender's office.
Oh, I want to resolve it today.
Jara McLawrence.
Okay.
He's telling me he was on probation, but I just don't want him. I don't want to chance it, and that he.
I mean, I'm looking at the probable cause affidavit on the second page.
They're
Says
saying you're on
records
probation.
reveals that he's on probation until 8/16/2020 and it lists the charges.
Wow.
So I'm gonna appoint Mr. McLawrence to represent him. The bond is gonna be set at $500. And he will have a hearing when? Status on the 6th. Good luck, sir. Curtis Murphy. Mr. Murphy, you've been charged with battery, touch, or strike. That's count 1. Count 2, the unlawful assembly, commit breach of the peace. The court, having reviewed the probable cause affidavit, is going to find probable cause.
Hey, so let's do this. What's your
Charges
name?
increased
You
violations,
decide later.
conditions of free trial. Case number 16-00.
Judge, I know pretrial just submitted an affidavit for violation. I can tell you, the court does have discretion. The court can increase his level of supervision on pretrial if they want to. The only thing I'm concerned about, he's currently a senior in high school at Sun Ed. He's supposed to graduate this year. He's born and raised in Fort Lauderdale, Florida. In light of his youth, will the court consider maybe placing him on an ankle monitor, a level 2 pretrial release? Maybe he was on standard. The court can always increase the level of supervision. It is in the court's discretion.
State's position.
I'll leave it to Your Honor on this case.
Pretrial. Well, what about his recommendation of increasing the level of pretrial and do the ankle monitor?
I cannot, Judge, I defer to you. I can write an order and you can sign it. I defer to you.
Okay, well, I think instead of, yes,
You can revoke the current pretrial and place him on a new term of parole pretrial release and add the condition that you can add in curfew, that he be at home at a certain time, and you can also add the condition that he have an ankle monitor or a GPS monitor.
you're saying that I can revoke the current pretrial and then enter.
And then modify it.
And then, well, I'm not modifying. If I revoke it, it's revoked. So it would have to be a
No,
new.
but then you would place him back on pretrial.
At a higher
and then,
level.
At a higher level, yes.
Okay, I'm gonna put this on recall so pretrial can, do some investigation.
Thank you. Have a seat, sir.
This case is also related to the 2 juvenile cases. Yeah.
No, he's on
Ryan
recall.
Parker,
He's on recall. Judge, he posted bond.
Demetrius Lamont Fulton,
He's present at the main jail.
His bond was posted.
I was told that his bond has been posted.
Good luck to you.
All right.
Quentin Delaney Taylor.
No problem, Your Honor. No problem.
Sir, you've been charged with resisting officers' obstruction with violence, leave the scene of a crash involving damage to property. Are you representing him?
Yes, Your Honor.
And the court has reviewed the probable cause affidavit and finds that there is probable cause. The bond as to count 1 is $100, and as to count 2, there's no bond as to count 2?
Your Honor, there's no charge.
No charge. Okay, so there's no. Go ahead.
Just in considering his bond amount and speaking with Mr. Taylor, it doesn't look like he has much criminal history. He's not a convicted felon. He lives with his mother. He does not have any children. He's been in South Florida most of his life, Your Honor, and he's never missed court before. He has no way of getting in contact with his mother, who would be the only one to bond him out, because he doesn't know her phone number. It's not committed to memory, and so we would ask if the court would consider releasing him ROR, as these are 2 misdemeanor offenses. Hello?
State.
Your Honor, I would ask that the bond remain at the standard $100 bond for this charge based on the nature of the charge and the fact that he also has a pending battery case with 3 counts, Your Honor.
Well, he has a pending case. He hasn't been adjudicated, so I'm
Correct,
going
Your
to release him on his own recognizance. And when is his next hearing? Okay. Good luck to you, sir. Michelette Pavilion.
She's been released, Your Honor. He's been released.
Stephen Williams.
He's present at the main jail.
Stephen Williams.
Your Honor, he's been county sentenced. He's not going to be released until November. I would just ask the court to keep the bond at $1,000.
Okay, the court has reviewed the probable cause affidavit. It's finding probable cause. He's charged with possession of cannabis, 20 grams or less, and introduced contraband into detention facility. Have a good day. Shane Jason South.
He's present at the main jail. Judge, I believe this is an ad charge. I was informed by Mr. South that he's awaiting a program, a residential treatment program, Spectrum. His cases are in mental health court. I think he had a violation of probation. Judge Porth reinstated his probation. I believe he was scheduled to be released to the program, but then we're here on this ad charge. What I would respectfully ask is, I'm unable to see on the computer what was done with counts 1 and 2. If we could verify that if he's been released to the Spectrum program, I would ask the court to release him on those same conditions on this particular count.
I'm going to try to look up the order now, if I may.
So we're gonna put it on recall, or? Yes, we can place it on recall. We're gonna go ahead and place it on recall. Joseph Anton Hilton.
Here, Your Honor.
Conti, Your Honor.
Here.
Mr. Hilton, you've been charged. This is a KPS on a felony. The court has reviewed the warrant and finds probable cause. The bond amount is $5,000. And your next court date will be? We don't have a date available right now. You'll be advised. Have a good day.
Thank you.
Murphy? We're back on Curtis Murphy. Right. Okay, so I'm on the Curtis Murphy case. The court haven't found probable cause. I'm going to revoke the existing pretrial order, and then I'm going to enter a new pretrial order, increasing the level of supervision to ankle monitor, no contact with the victim, and all the other conditions of the pretrial. Yeah, you had you wanted something also regarding curfew?
No, it's up to the court. I mean, that's an option the court has if you want him on a curfew.
Yeah, I think I want him on a curfew. What's the standard curfew?
I don't know if he works or goes to school, he has to say.
Do you work? Does he work?
No, I don't think he works.
He goes to school?
Shane South.
He goes to school at
What are the
Sunhead.
Okay, he
hours?
said it was released to a parent.
What are your hours at school?
So he has
12 to 5, Your Honor.
cases, the judge reinstated his mental health probation. Reinstated, modified.
Okay, the
he's
court is
staying in
going
custody
to
until
order that you have to be
next-
home by 7 at night.
He is released to the spectrum.
Okay.
That was done on September 14th, 2016.
No drugs
Okay,
or
thank
alcohol, any of that, right?
Right there.
Good luck to you, sir.
All right. Thank you, man. Thanks.
We are ready to go back on Shane South.
Recalling Chain Jason South.
On Mr. South, Your Honor, I have verified that on September 14th, he did resolve both of his violation of probation cases, where the judge reinstated him back onto mental health probation, and he was ordered to remain in custody until a bed became available at Spectrum in Dade County, which he's currently awaiting. We're asking if the court would ROR him on this count 4 so that it doesn't hinder him from being released to Spectrum once the bed is available.
This count 4 is a new charge.
It's a new charge, yes, Your Honor. He was,
Was it a new charge that he picked up, or was that as a result of the underlying?
a new charge that he picked up. So he has two new drug offenses. The other one he's already been ROR'd on by his judge, and this one was just add charged. And so we're asking if he can be ROR'd on this one as well.
State.
Based on the document that defense counsel showed me, I have no objection, Your Honor.
Okay, so he's going to be released on his own recognizance. Good luck to
Public
you,
defender.
Mr. South. Alexander Jimenez Gomez, or Gomez Jimenez.
No problem, Your Honor.
Mr. Jimenez, you have been charged with felony battery. The court is finding probable cause. Do you understand your charges?
This felony battery is the what battery is this? The one I
Okay,
caught
first of all, I want
against.
to remind you that you have the right to remain silent. Anything you said may be used against you. Does he have a public defender?
Yes, Your Honor, we will be representing him. This is an add charge for an offense that occurred inside of the jail, Your Honor. I would be asking that he not make any statements as to the facts of the case, Your Honor.
Okay, so the court is finding probable cause on the felony battery, the new charge of felony batter while in jail.
And we're asking if the court will consider setting a standard bond of $1,000 on this case.
No objection, and can you please order no victim contact, Your Honor?
Court is gonna set the bond at $1,000, no contact with the victim. Good luck to you.
Yes, ma'am.
Frederick Wardon. Frederick Wardon.
Judge, he's being held no bond on. He was before Judge Davis yesterday. He has some punishable by life offenses where he's being held no bond, no. And I would just ask the court to set a regular $2,000 bond on count 9.
State.
He's being held no bond anyway.
No objection, Your Honor.
Count 9. What's the bottom amount? He said 2,000.
Yes.
Court, having reviewed the probable cause affidavit, is finding probable cause. As to count 9, the court is going to set the bond at $2,000. Count 8.
No, that's okay, I'm sorry. No, it's okay.
Yeah. Jeff LaFear.
He's present at the main, Judge.
Sir, you've been charged with aggravated battery with a deadly weapon. The court has reviewed the probable cause affidavit and is finding probable cause.
Violations condition of true child, case number 16006843 CFNA.
Okay.
I would just ask to see if this incident, I think it's a not in custody warrant, if this happened prior to him being on pretrial. If it happened to him, if the alleged incident happened prior to him being on pretrial, he may not be in violation of his pretrial release.
It says that this happened on July 4th, 2016. He grabbed a knife and stabbed the victim twice on his stomach.
He was placed on pre-trial July 7th, it looks like. I'm sorry, the agreement was filed on July 7th.
He was arrested in June, but he was placed on pretrial service in magistrate court June 30th to be exact. So I don't think this is a good revocation. It's up to you. If you want to put no bond or reject the revocation or no bond.
Well, this is, so when was he placed on pretrial?
June 30th.
And when was he, when was he, charged?
The new charge in the case?
No, the, when was the first case where he was placed on pretrial intervention? You said he was placed on pretrial intervention on June 30th. Was that done at magistrate?
Yeah, it looked like Judge David put him on pretrial services June 30th.
Okay, what's the public defender's position?
Judge, what's the date of incident? Unfortunately I don't have his probable cause affidavit.
Probable cause affidavit, date of incident says July 4th.
Okay. It would be afterwards, so.
Right, so that means if he was placed on pretrial on the 30th, and this offense occurred on July 4th, so, the court is going to, revoke his pretrial services.
Judge, will the court set on the new case, set a $2,500 bond? He's gonna be held no bond anyway on the pretrial release.
What's the state's position?
On this case, the standard bond would be $3,500, so the state would be asking for that, as well as no victim contact, Your Honor.
Okay, the court is gonna set the bond at $3,000 and no contact with the victim. Travis Ortez Anderson. Sir, you've been charged with burglary with assault or battery. The court has reviewed the probable cause affidavit. Anything from the public defender?
I can tell you that in speaking with him, he was residing with his girlfriend. They've been together since May. So there may be an issue of the residence, him residing there and living there with his girlfriend. The issue of that being his residence. But other than that, I can tell you that he works in produce at Premier Produce in Dania Beach. He was born and raised in Miami. He's been living in Broward for 2 months. I would ask the court to set a $2,500 bond on the case.
Your Honor, in this case, this is a punishable by life offense, so bond should be set before the division judge, Your Honor.
Yeah, I'm gonna let the division judge, right now, I'm gonna leave it at no bond, and have the division judge address the issue of bond.
Judge, at this time, I'll just invoke his right to remain silent.
Okay, the court having found probable cause is finding no bond.
And Your Honor, can you order no victim contact?
No victim contact. Richard Leon Raspberry.
Court dates next week. Okay. No, we'll just let the judge know.
Court has reviewed the probable cause affidavit, and finds probable cause. The defendant has been charged with violation of probation, it's a felony. And, anything from the public defender?
Nothing, Judge. It's a BOP. I'm not in a position to ask for a bond.
Thank you.
Thank you.
Annie Mohammed Fario.
He's present at the main jail.
Good morning, Judge.
Good morning, sir. You've been charged with grand theft. The court has reviewed the probable cause affidavit. Yes.
He's been a resident of Broward County for 10 years. He has an associate's degree in New York. He went to middle school, high school in Broward County. At this time, he's not working and doesn't have the funds to bond out. If he doesn't have an extensive history, will the court consider ROR?
Let me hear from the state.
The standard bond for this charge, Your Honor, is the $1,000. That's what the state would be asking for. In regards to his priors, he does have a pending case. It's a driving case, driving while license suspended in front of Judge Backman. And then his priors, he has
Backman is doing a
driving while license suspended.
Arlene
Yes.
Backman. Okay.
And then the priors start in 2002, Your Honor. It's a burglary of an occupied structure or conveyance, was an adjudication. In 2002, a grand theft adjudication. 2002, possession of cannabis, withhold. And then there's driving priors from 2002, driving while license revoked adjudication. 2002, once again, driving while license revoked adjudication. And
The
2000.
victim in this case is his father. Do we have any communication regarding that?
Yes, the pretrial spoke to his father, and his father, since his father was a victim in this case, his father says he needs help and he cannot return to his home residence.
Okay. Does he have a place to go to if he can't go to his dad's house?
He said he could maybe stay with his brother, but he hasn't contacted him yet.
Friends, yeah.
He can stay with his brother?
He has to call him.
Would pre-trial, if he
They
can
won't
stay
be
with his
able-
brother, would he qualify for pre-trial?
Can't do it. Fine, huh?
He won't chill.
The victim said that he needs help. Do we know what kind of help he needs? I mean, with drug court or mental health, huh?
Drug treatment.
Drug treatment? So would this be a case that might be appropriate for drug court?
Charge, we wouldn't look at it as the charge, but it's up to the judge's discretion.
Okay, I'm gonna order a pre-trial, is she here on that case? No. Okay, I didn't recognize you without the uniform. The court is going to find probable cause. I'm going to order it to pretrial intervention with confirmation with the relative, with verification. And what's the issue on the bond? Standard bond is $1,000?
Yes, Your Honor.
What's the issue with the bond?
Judge, I would ask for either a pretrial release pending verification or in the alternative, $1,000 bond.
Okay, so I'm going to release with pretrial intervention upon verification.
And Judge, I think he has phone numbers in his cell phone. Pretrial release is going to call him to get his brother's cell phone, his brother's number, in order to verify him. Would the court sign an order to allow him to have access to his phone contacts and property, so he can give pretrial release his brother's phone number?
I don't have a problem with that. Does anybody have an objection?
No objection, Your Honor.
Okay, he can have access to his phone.
So give him your brother's number, okay?
Yes, drug and alcohol eval.
Drug and alcohol eval.
Random drug testing.
Random drug testing.
Okay. Well,
Okay.
with the pre-trial?
Yes. And there's a
Defendant verification. Norman Edward Leonard.
present at the main, Judge.
Good morning, Your Honor.
Good morning. Sir, you've been charged with aggravated assault with a deadly weapon without intent to kill, touch or strike battery.
Judge,
Go ahead, counsel.
there's not enough. I mean, based on what I'm reading from the four corners of the document, I'm not going to make a probable cause argument. But I could tell the court that in speaking with Mr. Leonard, there's a little bit more going on than what's in the four corners of the document. He currently resides with his mother, who's currently in ICU. He takes care of her, and whatever is happening stems from a dispute over the care for the mother. I was advised that one of the alleged victims in the case took a cell phone from the hospital bed, and he went to retrieve it from the nurse. I could tell you that he's gainfully employed. He builds pools. He's a resident of Broward County for 40 years. He would be relying on his girlfriend to bond him out. The most he can afford at this juncture is $500 because he spends money for the bills and he's helping to take care of his mother. But he does have a place where he can reside. I would respectfully ask for a $1,500 bond on count one and $1,000 bond on count two.
Are you here on this case?
Yes, Your Honor, I am.
Who are you?
For the record, my name is Carol Eddy.
Uh-huh.
I've known Mr. Leonard for most of his life. I'm a friend of the family. His father passed recently.
Can I put you under oath?
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Everything you've told me is the truth and nothing but the truth?
Yes, Your Honor, it is. I don't believe any of these incidents are what they are purported to be. I've talked to several people, several members of the family, and this will have to all come out later. But I'm here to support him. If there's any possibility you could give him a bond on those, I'm sure he won't have any more contact with
What's
the parties.
the state's position?
Fires? Yes, only in 2002 there's a disorderly conduct, Your Honor.
So what's the state's position?
The position, I have no objection to the bond set by defense counsel, $1,500 for count one and $1,000 for count two with no victim contact, Your Honor.
Okay, the court is finding probable cause. Is he able to make bond?
I believe so.
I have to get a hold of my girlfriend.
He has to get a hold of his girlfriend, but he told me $500. That's the most he can afford. So, in light of having somebody who works at the courthouse who can establish that he does have ties to the community, would the court consider RR in count two and putting a $1,500 bond on count one?
Any objection from the state?
I would just ask to have it remain at the standard bond, Your Honor, for this charge.
Okay, as to count two, the court is going to release him on RR. No contact with the victim. As to count one, the bond is gonna stay at $1,500. Good luck to you, sir.
Thank you very much, Your Honor.
You're welcome. Corey Dukes. Mr. Duke, you've been charged with count one, burglary, unoccupied dwelling, unarmed, count two, grand theft, count three, criminal mischief. The court has reviewed the probable cause
Your Honor,
affidavit.
and I would have argument as to probable cause.
Okay.
Just in reviewing the probable cause affidavit, there's nothing here that shows that a burglary was committed. The only thing in the four corners of the document is that it states that he assisted in removing the victim from his home. It's not clear if they were all already in the home, if there was entry afterwards. It's not clear at all. It seems that everyone was already in the home and these two may have left the home. In that instance, Your Honor, if they were allowed entry into the home, it wouldn't be a burglary. I can understand the grand theft or the criminal mischief, but it wouldn't be a burglary.
State.
Your Honor, there is a post-Miranda confession from the defendant for the burglary.
Right, I did see that in the probable cause affidavit. There's a confession.
It states that they advise that he took part in removing the victim from his house, thereby distracting him, so that the defendant could steal the victim's belongings. Nothing in this probable cause say entry was made at this point, the victim wasn't home or anything. It's just not clear, Your Honor. It seems in reading it seems that it seems like they know each other. They may have been hanging out. Him and the victim may have left the home and these other people were already there and may have stole property. That's what it seems like to me. But again, there's nothing in this probable cause affidavit that would support a finding of probable cause for a burglary of a dwelling.
Does the state want to perfect the probable cause affidavit?
Can I make a proposal to the state judge?
Yes.
State, if you would agree to pretrial release on all three counts, we may be willing to waive the probable cause argument. He's a high school student. He studies at Mavericks. He has a child he has to take care of. He lives in an apartment.
3 months old. Huh? State?
I couldn't hear.
Pretrial release with what conditions would be on the
I mean,
defendant?
the standard pretrial conditions. I mean, he's a student. Allow him to go to school and work. Take care of his family. No drugs, alcohol, obviously.
Your Honor, I'll just ask for 48 hours to perfect the information.
Okay, 48 hours to perfect.
And Your Honor, it is in your discretion to set a bond amount on these counts until the state has an opportunity to perfect. And we'd ask if Your Honor would still consider the pretrial release, being that he is a high school student, he does have a child to support, and he does have a job.
He has a child to support?
Yes, Your Honor.
Okay, well, I'll release him on pretrial and the state can perfect in 48 hours. With a standard condition, does he qualify for pretrial?
He would have to speak.
Yeah, I would, standard pretrial. Yes. Right. Right. I'm giving them 48 hours to perfect. Pretrial.
If you put him in pre-trial, he's gonna be released today.
Right.
Okay, so he'll come up with perfection.
Right.
You still would like a perfection, Your Honor?
Yes. I mean, if you don't want to, then I guess he'll be released.
If you put him in pre-trial, he's going out today.
Right, right, I understand that. I mean, you asked for 48 hours to perfect.
Right, so are you going to hold on 48 hours for the
No,
pretrial?
I'm not holding, I'm gonna put him on pretrial, and if you perfect, you perfect. Yes. Yep.
Your Honor, defense counsel had said that if the defendant goes out on pretrial intervention, then they would stipulate to the probable cause. So if you're going to allow him to go out on pretrial, then wouldn't they be stipulating to the probable cause?
Okay.
She rejected my offer.
Huh?
And now the court wants him to perfect and place him on pretrial, so.
It's fine, Your Honor.
Okay.
They'll foul
So,
I mean, I'm concerned, I just want, he has a lot going on. My concern is him. My intention was
well,
to ask for
the
pretrial
state now
release.
has changed their mind, and they're willing, I guess they're willing to agree to your conditions. So they're.
Thank you, State.
You're welcome.
So you're waiving the probable cause argument.
Yes,
And he.
yes, I am, Judge.
Okay.
Thank you, and I would like to thank the state attorney.
Your Honor, North Broward indicated that they are ready on Monique Miranda, the juvenile that was held back.
Okay. North Broward, Monique, Nicole.
Thank you, Your Honor.
Judge, because if this is a juvenile case, it's being streamed by the Sun Sentinel. So because of I think there are different rules for regards to juvenile defendants. I would just ask the court to go off the record because, yeah, so not off the record, but shut down the camera.
We're going to do here at the
Sidebar.
end.
Okay. The court can go sidebar. I think the court can go sidebar if you want to do it, and I won't be able to hear it. Nobody else will hear.
I just pressed juveniles, so can anybody?
I
can hear that?
I can still hear you.
They can still hear me. So where's the sidebar button here? Audio control. Sidebar. It's on now. We changed it now. It says on.
Okay, make sure they can hear you.
Joseph Alborno.
She's gonna do it at the end.
Present at the main.
Good morning, Your Honor.
Good morning, sir. You've been charged with violation of probation, count 1, violation of probation, count 2. There's no bond on both. Anything from the public defender?
No, Judge, I have no problem. I mean, I'm not in a position to argue for a bond.
Court finds probable cause. Have a good day, sir.
All right, you have a great day.
Wadley Nordilas.
Gentleman recall, he went to the restroom.
Judge, he went to the restroom. Recall, please.
Oscar Alfredo Estrada Nunez.
Same thing.
But he went to the restroom, Judge. Recall, please.
Do we need to take a bathroom break?
Yeah, 2 people did.
Okay. Kerry Stephen Cam. Mr. Stephen, you're here on violation of parole. There's no bond. Any objection to the finding of probable cause?
No, Judge.
Have a good day, sir. Junior Torres.
Judge, he needs a Spanish interpreter. There should be one there.
We have one here. Mr. Torres, you have been charged with count 1, grand theft.
Señor Torres, lo han acusado de hurto cuantioso.
Count 2 is fraud, uttering of a false instrument.
La segunda acusación que tienen en contra suya es de presentar un instrumento falso.
Count 3 is possession of a counterfeit driver's license.
La tercera acusación es de tener en su tenencia una licencia de conducción que no era real.
Any objection to the probable cause affidavit?
Pregunta la señora abogada, la señora juez, si hay alguna objeción en cuanto al affidavit de motivo fundado.
I would defer to my counsel in the courtroom, Judge. I didn't get a chance to read his probable cause
El
affidavit.
señor abogado defensor allá presente le dice a la señora juez que el señor abogado presente aquí en la sala hará el argumento.
No, there's no issue. He wanted you to, he said he's not familiar with the affidavit.
I've reviewed the probable cause. I don't see any argument.
La señora abogada presente aquí en la sala dice a la señora juez que ha revisado el affidavit de motivo fundado y no ve posibilidad de hacer un argumento.
Does he have any priors?
None from Florida, Your Honor.
Pregunta si hay antecedentes y la fiscal responde que no encuentran antecedentes aquí en la Florida.
Is he able to make bond?
¿Puede pagar una fianza?
Can you afford $300?
¿Puede pagar $300 de fianza?
Sí.
Yes.
I would ask the court to keep him on maybe ROR, one of the counts, in light of the fact he has no criminal history.
Pregunta el abogado defensor a la señora juez, así lo podrían dejar en libertad bajo su propia responsabilidad en cuanto a las otras acusaciones, debido a que no hay antecedentes.
Any objection from the state?
I would ask that the bond remain the standard bond, Your Honor.
Yes, to count 3,
La
the
señora
court is
fiscal-
going to release him on ROR.
La señora fiscal pide a la señora juez que deje la fianza como está. La señora juez lo deja en libertad bajo su propia responsabilidad.
On count 3.
En cuanto a la acusación número 3.
Count 1 and 2, the bond will remain at $1,000.
Y en cuanto a la acusación 1 y 2, las fianzas que han impuesto de $1,000 cada una permanecen vigentes.
Good luck to you, sir.
Buena suerte, señor.
Judge, we do have Mr. Watley and Estrada Nunez here.
Okay.
Does he need a Spanish interpreter?
Oscar
No, no.
Alfredo Estrada Nunez.
Mr. Nunez is here.
Okay, Mr. Estrada Nunez, you've been charged with count 1, domestic battery by strangulation, dating relation, and count 2 is a misdemeanor capious. Any objection to the probable cause affidavit?
I'll defer to counsel, Judge.
Counsel?
My apologies, Your Honor.
This happened in July. Why is it just now coming here? Was there a violation?
So,
He failed to appear, or?
This is a not in custody case, yes.
it's already filed.
It's Judge Cohen's case?
If Judge Cohen if Judge Cohen found probable cause, Judge, then legally we can't argue against probable cause. We could argue maybe mitigation, but there's nothing that I can't tell the court that Judge Cohen shouldn't have found probable cause.
He entered no bond hold.
Well, Judge, but no, it's a no bond hold until magistrates. So it is a bondable offense because it's not a punishable by life offense. The court would take into consideration his ties to the community and set a bond in the case.
What's the state? What's the capious for then?
The capious is the not in custody capious at the time of the.
Okay.
You look at the warrant, it's not time for the time for the court.
What's the state's position?
Your Honor, can we hear from the victim in the cases here? I believe she would like to speak.
Oh, I'm sorry.
It's okay.
If I can have her raise her right hand to be
Yes.
sworn in.
Yes, I do. Claudine Mogilevsky. And by the way, if I ever have a daughter, her name is Marina. I said that a long time ago, so it was very cute. Mr. Esquada and I have been together for quite some time. He's the father of my son. He is a wonderful person. He supports his kids. He supports me. He and I have never had any sort of issue or incident. And when I read the charges, they were wildly exaggerated.
Are you the victim?
I am. You know, I've been with him, like I said, for a while. We've never had any issues.
What's a while? How old are your children together?
We have an 11-month-old baby.
Okay.
And we've been together for 2.5 years. He is, I'm sorry, I lose my train of thought. He's gainfully employed, and yesterday, when the DCF worker called him to tell him that there was court to go, you know, for our kids, he immediately came and turned himself in. He's not trying to.
Your children are in DCF custody?
They're with my parents.
Right.
So,
So the children were removed from your care?
from my care as well.
Okay, as a result of this incident, or?
As a result of this, because when I I only read the petition yesterday, and when I read this, I said, this is completely exaggerated. This is not what happened. And I
Who is
just,
the dependency judge in your case?
we met before Judge Schulman yesterday. So it hasn't been assigned, it's just
Have
brand
you
new.
been given a case plan?
I'm going to. I'm talking with Child Net.
Have you been,
later today.
have you had your arraignment on the petition for dependency?
Not yet.
Do you have an attorney that's representing you?
I do.
Your attorney?
Courtney Montiero.
Okay. Is that a state-appointed attorney?
No,
It's a private attorney?
Yeah.
Okay. So you don't know if you've been arraigned on the dependency charge?
There was no charge against me. They just happened to take the baby and put him with my mom, and then he got arrested.
There had to be an adjudication of dependency in order for the kids to be removed from your custody and place them with your mom.
I guess it happened yesterday. And I'm
That
sorry,
happened
I'm not
yesterday?
like, yeah, I'm not really familiar with.
Did you go to court yesterday?
Mm-hmm.
And prior to yesterday, were the child with you or with?
With
Okay.
both of us. We're his parents.
Okay.
We love him.
So, anything else you want to tell the court regarding your relationship with Mr. Estrada Nunez?
It's a beautiful relationship, and these charges, we just had a fight, and, you know, things happen. No one's perfect, but.
Is there any other history of domestic violence?
No, Your Honor. None in
What's the
Florida.
state's position?
I would be asking for the standard bond on this charge, which is $1,000, and no harmful contact with the victim.
And that's for number one, right?
Yes, Your Honor.
And for number, so is the total would be $1,250, so are you able to make bond?
Judge, he can make that. No. Can you make that bond?
I can make that bond.
He said he can make that bond.
Okay, so as to count, court is gonna find probable cause. The state wants no contact with the victim.
No harmful contact. I believe they still live together, right?
Yes.
Okay.
So what does that mean?
No harmful
Just to-
contact.
Okay.
That means that you can live together, but he can't hurt you.
Okay.
My radio reaches me.
I'm gonna set the bond as to count one at 1,000.
Judge, can we ROR count 2 because it's from 2002?
2002.
Yeah. And he wants to take it to trial.
Okay, what's the state's position on count 2?
I would leave the bond. I understand the case is from 2002, but it was a capias. He hasn't turned himself in, and he had all these years to go in, and now he was picked up on it just yesterday or 2 days ago.
I think he thought it was done, but.
Okay, as to count 2, I'm gonna ROR. Ma'am, good luck to you.
Thank you.
Have a good day.
Thank you, you too.
Alan Garcia Vera.
I think we need to do Watley.
Defendant bond.
Oh, I'm sorry. They, Garcia bonded?
Yes.
And you're right, we need to go back to Watley Nordelius. Mr. Nordelius, you've been charged with grand theft, count 1, and probation violation of community control. Any objection to the probable cause affidavit?
Your Honor, my only argument would be there's nothing here that indicates Mr. Nordelis knew that he was removing tires from a stolen vehicle. If reading this probable cause affidavit in conjunction with the other arrestee, Your Honor, and I forget her name, I would have to go back and check it. But in that one, it says that they were parked and that she had the keys to the vehicle, and that he removed tires and placed them in the back of another vehicle. It's nothing here showing that he had knowledge that the vehicle was stolen. It seems like he was just assisting her in removing tires.
State.
Your Honor, in this case, the grand theft was removing the tires and rims from the vehicle. I believe that is enough for the grand theft, Your Honor.
But our argument is the probable cause just says that he removed tires. Removing tires in and of itself is not a crime without more. So without him having knowledge that the tires he's removing are stolen or from a stolen vehicle, there's nothing to show that he knew that. The other person who was involved had the keys to the vehicle.
I agree. I mean, removing tires from a vehicle is not a crime. Where in the probable cause affidavit does it say that
You're gonna have to come back. They're gonna have to ask for perfection.
that Can you the
Perfecting the
Mute.
what the state's gonna do.
tires were stolen? Which was reported stolen by the victim. But there's nothing here saying that he knew that the tires were stolen. So what does the state want to do? I'm inclined to find no probable cause.
I would ask for 48 hours to perfect, Your Honor.
Okay? 48 hours to perfect. Cornelius, count one. Count two was a, so. Cornelius Otis Harris.
Present at the main.
Count two what, I'm sorry? So find, can I just defer until they perfect?
So you need both of them to come back and not just the perfection and leave it on.
Well, count two was the, it says probation violation of community control. No, it says no bond.
Yes.
Yeah.
Yes, it is because of count one.
I don't see it, there's a probable cause affidavit.
Correct, then put an argument down.
So we'd ask for both of them to come back.
Okay, both of them will come back.
Okay. Mr. Harris, you've been charged with aggravated assault with a deadly weapon without intent to kill. That's count one. Count two, aggravated assault with a deadly weapon without intent to kill. And count three, possession of weapon or ammunition by convicted Florida felon.
Judge, I think just going and reviewing the probable cause affidavit, there are two witnesses that heard gunshots, but they didn't see who shot. They didn't see anybody who shot. The only witnesses are the people who are accusing him of this, even though they found a gun shell, but they didn't find a gun or any fingerprints on the weapon. I would ask the court, if the court were to find probable cause, I would ask the court to set a reasonable bond on counts 1 through 3. And he does have a job. He does have a job on Monday, landscaping and construction. He does also work with Workforce One. Whenever they have a job, he's working with the temp agency. He was born in Broward County, actually at Broward General Hospital, and he lived here all his life. I would respectfully ask. I would respectfully ask the court to set a $1,000 bond on each count.
State.
The standard bond would be $1,000 for each count. I have no objection to that, Your Honor.
Do you have an objection to the bond at $1,000 for each count?
No, Judge.
Okay. Court is setting the bond as to each of the counts at $1,000. Court is finding probable cause. Can he make the bond?
Arrested with 400. Judge, he says he has money in his property. Would the court sign an order to allow him to have access to his money?
Yes.
For purpose of posting bond? Thank you.
He can have access to his property. Do I need to include that, or can we do it separately?
And Your Honor, in this case, can you order no victim contact as well, please?
No victim contact. Mark Nolshin.
He's present at the main jail, Judge. Good morning.
Good morning, sir. You've been charged with count 1, battery on an officer firefighter, and count 2, battery on an officer firefighter. Does the public defender have an objection to the probable cause affidavit?
Your Honor, I just argue the fact that he was in the emergency room, obviously to receive treatment, it seems that there was something wrong. I don't see how anything he did could have been intentional. He was obviously there to receive treatment. Whatever may have transpired, it says he flailed his arms. I'm not sure how flailing your arms, if you're in pain or whatever may be going on, could be seen as intentional. They're there to treat him.
Recommendation of a retrial?
You're getting out of jail. Pre-trial release.
Any objection to the state?
Not at all, Judge. I'm sorry.
No objection, Your Honor.
Okay, so the court is going to find probable cause and do pretrial release. Any no contact with the victim?
All right.
Thank you.
No contact with the victim.
No problem. Thanks.
Sir?
Corey Cruz. COI-COU.
What other charge?
You're welcome. Angelo Diamante Coico?
Yes, ma'am. He's present, Judge.
Okay, sir, you've been charged with battery by person detained in prison. Any objection from the public defenders in the court finding probable cause? Court finds probable cause. Have a good day. Malcolm Jamar Turner.
Your Honor, on the previous one, can you order no victim contact?
Sure.
Thanks.
Good morning, Judge.
Judge, this is a change of charge. I would have, normally what we normally do in magistrate's court is, on the change of charges, we normally ask for the same bond to be placed as the previous bond.
Which is what?
I don't know. Confinement should know.
How much? $2,500.
Okay.
State.
Thank you, Judge.
No objection, Your Honor.
Anthony Johnson.
Anthony Ray Johnson. Sir, you've been charged with a felony capias. Any objection to the probable cause?
Just my only question is this a not in custody capias, or is this a capias because he missed court? I'm not sure.
It looks like he missed court only because he has a status date already set. So it looks like
Okay.
he missed court.
Okay, I don't have an objection.
So what's the bond?
It would be no bond, Judge, because you have court next week, the 6th.
Status on the
All right.
6th. No, we have one more. We have Scott.
Judge, he's a medical reset.
Scott?
Scott Krasnick is a medical reset.
Okay, so now we have Monique, Nicole, and
Judge, I'm clear at the main. May I be excused?
you may.
Judge, it's an honor and pleasure being in front of you. Take care.
You too.
Her hearing to be aired live.
But she needs to be able to hear me.
Most Broward needs to be able to hear it.
Yeah.
We can't.
Okay, so should I just call her and we go off record and I call her on the phone so she can?
Yeah.
Yeah.
You want anyone to hear this?
Right, right, because it's too loud.
Not the